When is an agreement so unambiguous that it deprives a party of a right to sue? To find out, you have to read Mulechek versus ExxonMobil, but it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Mulechek versus ExxonMobil Corporation. The citation for this case is 2024 New York Slip Opinion 02724, published by the New York Court of Appeals on May 16th of 2024. The issue in this case is whether a provision of an agreement, of a contract, that prohibits plaintiffs from suing for breach of contract is unambiguous. To appreciate the context and background of this case, the background that I think is helpful to understand is that CPLR, Civil Practice Law and Rules, Section 3211, is the grounds for a motion to dismiss. A case can be dismissed by a party or by the court at the application of a party on a number of grounds. One of those grounds is based upon documentary evidence that establishes conclusively that a defense exists to the action. And that the party is entitled to that dismissal based upon that documentary defense. What are the facts in this case? The facts are that plaintiffs here, Mulechek and his co-plaintiffs, are shareholders of a company called InterOil Corporation. It's a Canadian oil and gas company. And the defendant is ExxonMobil, which is another oil and gas company, worldwide gas company. ExxonMobil agrees to buy InterOil, the defendant agrees to buy the plaintiff with 2 important provisions. First is that they're going to pay the shareholders, that they're going to pay the plaintiff shareholders a fee per share, and that they're going to make a contingent resource payment, a CRP, based upon an independent appraisal of the volume of resources that are found in Papua New Guinea, right? So there's an agreement about paying per share and the amount of money they're going to pay, but depending on how much oil and gas is found to be in Papua New Guinea in a oil field that InterOil and ExxonMobil have interest in. In that agreement, specifically, and this is the important part, the shareholders, the plaintiffs, become holders of receipts, entitling them to payment of the CRP, of that contingent resource payment. But the agreement specifically defines that there are different kinds of holders. There's holders, which are shareholders. And if a holder has more than 25% of the receipts, then it becomes what's called a required holder. And there's something called a holder committee, but only required holders and holder committees are allowed to bring a lawsuit. That's the important part here. Section 8.05 of the agreement says that ExxonMobil is going to calculate the amount of volume and resources that Papua New Guinea has and how much they're going to pay. But it says that holders have no rights under the agreement except as explicitly stated, and only required holders and the holder committee will have the right, on behalf of all the holders, by virtue of any provision of this agreement, to institute any action or proceeding with respect to this agreement. And no individual holder or other groups of holders would be entitled to exercise such rights. That's what the agreement says. Plaintiffs didn't like the CRP calculations that were being utilized, so they sued ExxonMobil, the defendant, alleging the defendant breached the agreement with respect to CRP payments. The defendant then moved to dismiss. Exxon moves to dismiss under 3211, saying, you have no right to sue us. Remember, the required holders, the holder committee, and you're just a holder. You don't have the ability to sue us. It goes to the Supreme Court, and they grant the application to dismiss based upon 3211. The procedural history is then it goes to the appellate division, and they affirm. They say the Supreme Court was right. And now it goes to the Court of Appeals. And here, they have to determine whether the case can proceed or whether it was properly dismissed. On that question, they say the question here is whether, when you're determining whether under 3211, a motion to dismiss is appropriate and should have been granted, the question here is there an ambiguity? Why? Because if the written agreement specifically states that there's a defense as a matter of law, then it should be granted. If there's an ambiguity, then it should not be granted. So they define what an ambiguous agreement is and an unambiguous agreement. And an ambiguity in an agreement is found when the agreement read as a whole fails to disclose its purpose and the party's intent, or when specific language is susceptible of 2 reasonable interpretations. An unambiguous agreement is defined as when the language it uses has a definite and precise meaning, unattended by danger of misconception, and concerning which there is no reasonable basis for difference of opinion. And applying that understanding of ambiguous and unambiguous, they say this language was unambiguous. The plaintiffs, as holders, have no right to sue. They only have a right to sue if they're a required holder or if they're a part of the holder committee. So under that grounds, 3211 is proper. Dismissal granted. Case dismissed. And that's the case of Mulacek versus ExxonMobil. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.